Welcome to Law and the Machine, where artificial intelligence meets the legal system, liability, regulation, intellectual property, and the government's uncomfortable role as both rulemaker and AI adopter. The law wasn't written for this.
So imagine a machine that can instantly generate content mimicking any style, any author, any artist, essentially creating infinite substitutions for existing works. And the company behind it says, this isn't piracy, it's fair use.
That's the core legal tightrope Meta, and frankly, every major AI developer is walking right now. They've built what amounts to an infinite substitution machine by training their models on vast troves of data, much of it copyrighted, and they're arguing that this process is fundamentally transformative, protected by fair use.
But transformation traditionally meant creating something new from the original, not just mimicking or substituting it. Are we seeing a redefinition of what copyright means in the age of AI?
Absolutely. The legal system is grappling with whether the act of ingesting and learning from copyrighted material, even if the output is different, still constitutes infringement. It's not about verbatim copying, but about the AI model's capacity to substitute for the original creator's output.
The very idea of an infinite substitution machine suggests an inherent challenge to existing creative industries. It feels like a direct threat to intellectual property in a way we haven't seen before.
It's less about a direct threat and more about a fundamental reevaluation of value. If an AI can generate 1,000 variations of a particular artistic style or a piece of prose that effectively replaces a human's output, what happens to the market for human creativity? That's where the fair use shield becomes critically important and deeply contentious.
To delve into that, the accusation against companies like Meta is that they've essentially built these incredibly powerful AI models by hoovering up copyrighted material without permission or compensation. What does the legal argument for infringement look like here?
The argument is straightforward on the surface. Training a large language model or an image generator involves making millions, if not billions, of copyrighted works. Each piece of text, every image, every audio file fed into the model is, in a technical sense, copied and stored in some form within the model's parameters. For copyright holders, that's prima facie infringement. They argue that these aren't just transient uses, they're foundational to the AI's commercial product.
So the act of ingesting the data is the infringement, not necessarily just the output.
Precisely. Many lawsuits aren't solely focused on the AI's output, though that's also a concern, but on the input. The claim is that without permission, the entire training process is an unauthorized reproduction and distribution of copyrighted works. It's like saying you built a factory using stolen blueprints, even if the cars it produces look different.
And Meta's counter-argument, their fair use shield, relies heavily on the concept of transformative use. How do they define transformative in this context? Because it sounds very different from, say, a parody or a critical essay.
It's a much broader interpretation. They argue that the AI models don't store exact copies of the original works. Instead, they extract abstract patterns, relationships, and styles, which are then used to generate entirely new content. The argument is that the purpose of copying isn't to reproduce the original, but to teach a machine to learn a skill. This learning process, they claim, transforms the original data into something fundamentally different, a predictive model, not a database of copies.
That's a fascinating distinction. So the original work isn't being displayed or republished by the model, but rather its underlying characteristics are being abstracted and repurposed.
Exactly. They would assert that the AI doesn't know the original work in the way a human does. It's just a complex mathematical function that has learned to predict sequences of data based on patterns it observed. From this perspective, the original work has been transformed from an expressive creation into a mere data point for statistical analysis.
But for the artists and writers whose work was ingested, it feels a lot like their creations are being used to train a competitor. The fair use doctrine also considers market effect. If this infinite substitution machine starts generating content that directly competes with and potentially devalues human-created work, how does that factor into the fair use argument?
That's the most challenging prong of the fair use analysis for AI developers. The fourth factor, the effect of the use upon the potential market for or value of the copyrighted work, is traditionally very strong. If an AI can generate a novel in the style of a specific author, or a song like a famous band, and consumers purchase that AI-generated content instead of the original creator's work, that's a clear market harm. Meta and others would argue that their AI generates new works that expand the creative ecosystem, rather than directly substituting for existing ones. They might point to entirely new applications or types of content that AI enables.
It feels like a distinction without a difference for many creators. If an AI can produce infinite variations of content that satisfy a market demand, it doesn't matter if it's new in some technical sense if it means people no longer need to pay for human-made originals.
That's the crux of the economic debate. The AI companies foresee a future where their tools empower a new wave of creativity, lowering barriers to entry and generating entirely new economic activity. Creators, on the other hand, see their established markets being eroded and their livelihoods threatened without compensation. The legal challenge is to reconcile these two visions under existing copyright law, which wasn't designed for this kind of technological capability.
What about the sheer scale of the data? This isn't just one book or one song, it's billions of data points. Does the amount and substantiality of the portion used, another fair use factor, still apply when it's aggregated at this scale?
It complicates it significantly. Traditionally, amount and substantiality referred to the percentage of a single work copied. With AI training, the model often ingests entire works. However, the argument from AI developers is that while they ingest the whole work, they don't reproduce the whole work in its original form. They extract statistical representations. So they argue the amount used is substantial, but the nature of that use is so transformative that the substantiality is mitigated. It's a very novel argument in copyright law.
So we're in a situation where fundamental legal principles are being stretched, perhaps beyond their original intent, by new technology. Is there a scenario where current fair use doctrine is deemed insufficient and new legislation is needed?
It's highly probable. Courts might struggle to apply the existing four-factor test in a way that feels equitable to both sides. There's a strong argument that the economic realities and societal implications of AI-generated content demand a fresh look at compensation mechanisms, possibly even a new type of compulsory license, or a collective bargaining framework for data used in AI training. Relying solely on the fair use defense, which is always a case-by-case fact-specific inquiry, creates immense uncertainty for both creators and AI developers.
For creators, what is the most important thing to understand about this infinite substitution machine and the fair use shield?
The key takeaway is that the legal battle isn't just about whether an AI copies your work. It's about the process of training that AI, and its subsequent ability to create substitute works falls within the bounds of what society deems fair. It forces a reevaluation of creativity's value, intellectual property's purpose, and who ultimately benefits from the aggregation and transformation of human culture.
And for the tech companies, the risk is that if fair use doesn't hold, the entire business model of training large AI models on public data could be upended, potentially leading to massive licensing costs or even requiring them to retrain models on explicitly licensed data.
Exactly. The stakes are enormous for both sides. The outcome of these legal challenges will shape the future of AI development and the creative economy for decades. It's not just about Meta, it's about setting a global precedent for how we value and protect intellectual property in the age of artificial intelligence.
So these cases are really pushing the boundaries of copyright law, forcing a reevaluation of whether transformation means something entirely different when a machine is doing the transforming.
It absolutely is. The very concept of authorship, originality, and economic harm is under re-examination. The traditional pillars of copyright were built in an analog era, and they're creaking under the weight of digital, algorithmic creation.
And perhaps the biggest question left unanswered by all of this is not just what the law says, but what should the law say to balance innovation with the rights of creators in this new technological landscape?
That's the legislative challenge ahead. It's a policy question as much as a legal one.
How do we design a framework that encourages AI innovation without gutting the creative industries that feed its very existence? It's a delicate balance, and there are no easy answers.
That's all for Law and the Machine. Join us next time as we continue exploring where AI and the law collide. If you found this useful, subscribe. We appreciate it.
The law will catch up, eventually.